Buenos días.
Good morning. From the Special Jurisdiction for Peace and our headquarters in Bogota, and together with the Swiss Embassy in Colombia, we want to welcome you formally to the second international conference, Emerging Responses to Contemporary Atrocities, Sanctions and Reparations in Terms of Victim Satisfaction and Institutional and Social Rehabilitation. We want to thank all of you who are joining us online from different places of the world, and therefore we will now give you the instructions to the access of this virtual event carried out in Spanish, English, and French. If you are following this session from your mobile phone, you can activate the interpreting by clicking on the three-dotted icon. There you will see a drop-down menu with the interpretation language option. Then you have to select your preferred language. So after selecting the language, you must click on the button Done, found on the top right-hand corner, and therefore you will start hearing the interpretation in English. If you are following us from your computer, you must click on the lower toolbar of Zoom and click on the interpreting module and select your preferred language. Those are the steps for us to follow the conference in our preferred language. So we want to cordially invite you to follow this conference in our social media, Facebook, in our Twitter channel as well, and on Instagram, as well as in our webpage, www.jep.gov.co. We will have open and closed sessions where your participation is certainly important. We now refer to the second conference. Well, because the first one, many of you were also joining us in October of the year 2020. We were in the pandemic in lockdown, and that's how we learn about the state of the art of transitional justice systems that we're currently in functioning or at portents of being. We had a success in that first conference because we combined all the inputs from the academia and specific examples from many professionals that were performing their functions in this model of justice. If you want to remember, perhaps check the results of that first conference. You will find these in the YouTube channel of the JEP, and also in the chat. We will share the link to this so you can follow up. That was the first conference. The second conference will now focus on all the ideals and ideal conditions for the sanctions and reparations in terms of victims' satisfaction and institutional and social rehabilitation and transitional justice frameworks that seek the following: victim satisfaction, also the legal safety of all stakeholders, social reconciliation, stability, as well as the strengthening of institutions. So, what we expect during these 2 days is to create much reflection and also be able to provide recommendations that can serve the different transitional justice systems that are currently existent in the world, regardless of the phase that they are in. This is a moment also to think Switzerland. Switzerland has been a very committed country with the peace agreement and a specific and strategic ally of the HEP. Also, the Swiss embassy in Colombia supports financially and technically this conference, and that's why we want to now hand the floor to Mr. Eric Alan Mayoras, Ambassador of Switzerland to the Republic of Colombia. Mr. Ambassador, please take the floor. Thank you very much, and good morning, all. Specifically, Mr. Eduardo Cifuentes, the current president of the HEP, as well as Roberto Vidal, the future president of the HEP, Luz Marina Monzon, director of the Unit for the Search of Disappeared Persons, as well as Father Francisco de Rue, former president of the Commission for the Clarification of Truth, as well as our great friend Carlos Ruiz Massieu, Special Representative of the Secretary General for Colombia and head of the United Nations Verification Mission in Colombia. So thank you very much for participating in this second international conference on transitional justice on the topic of emerging responses to contemporary atrocities. It's an honor for me to be here with you and open up this conference for the Embassy of Switzerland. It is very pleasing to join the HEB in this very important reflection that we hope can contribute key elements for the processes forthcoming. Switzerland has now supported over 20 years, as well as accompanying all these processes in different contexts, even in Colombia, of course. This experience has certainly shown us the importance that societies can find ways to face in a holistic manner and center mannered, having the victims at the core, the consequences of the conflict to also interrupt violent cycles and therefore establish a durable peace. The analysis of the past, and specifically in the non repetition guarantees, which is a key word in this, contribute to establish that key linkage between peace, security, human rights, and development. The systems of the comprehensive system created in Colombia in the framework of the peace agreement of 2016 between the government and the former guerrilla FARC EP have a great potential to this sense. Switzerland is absolutely convinced that the holistic approach of transitional justice with legal and non-legal measures is a core and central measure for reconciliation of societies, of human rights and humanitarian law. We want to congratulate Colombia for its efforts so that the value of all legal measures and non-legal measures can be acknowledged and used in in a cross-cutting way and in a complementary way by the different organisms of the comprehensive peace system. Although throughout the work developed in the last years, the HEP has been able to progress, always focusing on guaranteeing a focus on victims and also on the legal safety of all of those who appear before this jurisdiction. We are currently in a moment where, in this transitional justice system, is now complying to the retributive and restorative sanctions. Its implementation will contribute to the non repetition guarantees in the different territories of the country. Therefore, it's important for us and for most of the partners to ask ourselves how the imposition and the implementation of the sanctions contribute to satisfy the rights of the victims and at the same time acknowledge the responsibilities of those actors of the conflict and in this way contribute to reconciliation. This is an exercise we know very complex to really reach a balance between what has agreed within the peace accords between the government and the FARC and the needs and the claims of victims and the society. Most probably, no one will be fully satisfied, nor the victims, nor the accountable stakeholders of violations, nor the state, nor the society. However, without a doubt, this is the most ideal path, and we are fully convinced of this to be able to really build a stable and long lasting peace. In this historical moment in Colombia, this is a bet for total peace from this current government. And we want to highlight the key role of the transitional justice system that is being implemented in the country, which is unique in the world, innovative, and also based in the last standards at international level. To advance in this construction and to be able to count with sufficient tools to approach the challenges that are forthcoming, it's very useful to take into account the work that has been carried out in other contexts. And due to this, we celebrate this conference as a space to exchange learnings, experiences with experts from different parts and regions of the world and from different conflict contexts. So, from the Embassy of Switzerland, we want to highlight the role of the HEP of the comprehensive peace system as a fundamental element for the compliance of the final peace accord and as a system that is advancing in the consolidation and construction of long lasting peace in Colombia. So, we will now continue from in representation of Switzerland to accompany you in this process and also to reconfirm the trust we have in the Colombian state and institutionality. We also want to thank the former presidency of the HEP for its leadership in the progressive construction of this referent institution to the world, for its approach to transitional justice. And we also, of course, want to congratulate the new presidency for its election. And we want to reiterate Switzerland's support to continue building this innovative path. We hope you enjoy this conference, for all of those of you who participate in this online conference for its transformative potential. We hope that you can have interesting outcomes of this conference. And once again, we want to thank you for your participation. Thank you. Thank you very much, Mr. Ambassador. We want to also introduce officially the special representative of the Secretary General for Colombia and head of the United Nations Verification Mission in Colombia, Mr. Carlos Ruiz Massieu. Welcome. Thank you very much for this invitation. It's a pleasure to be here with you in this international conference, second international conference, focused on the emerging responses to contemporary atrocities. I'd like to firstly formally greet Mr. Ambassador Eric Alan Moiras, Ambassador of Switzerland to the Republic of Colombia, for the given support to this conference, and also especially greet President Eduardo Cifuentes of the Special Jurisdiction for Peace and who achieved, and the former president of the Commission for the Clarification of Truth, Francisco de Rue, as well as Luz Marina Monzon, the director of the Unit for the Search of Disappeared Persons, for her constant leadership as well. I'd also like to start by congratulating the new elect President Roberto Vidal from the HEP, Magistrate Vidal, as well as the VP, Magistrate Belkis Izquierdo, and I want to wish you most success in these next 2 years in these roles. And I would like to seize this opportunity as well to acknowledge the Magistrate President Eduardo Cifuentes, who has led with an impressive work the HEP in these last 2 years in the complex periods where we've also been witnesses of great progress in the work of the HEP and this work of this very important comprehensive systems as a part of the process and the peace accords in Colombia. To this extent, I'd like to highlight exactly that, the importance that the comprehensive system has, the importance of the role of the HEP for the peace accord. I think at the end of the day, the success of this accord will be measured by how much we can progress to a national reconciliation so that all Colombians can really advance in this path of unity, and that the comprehensive system has been, is, and must continue being that backbone where the HEP also has a very important role. This conference then is celebrated within this context. And as I've just said, we are who have been witnesses of very significant progress from the different institutions of the system, the work that the Commission for the Clarification of Truth has led under the leadership of Francisco de Rue and its report. And now we must take into account the very relevant recommendations that and also the advances of the Unit for the Search of Disappeared Persons with the leadership of Luz Marina Monzon. Lastly, with these very important agreements with Afro-Colombian and indigenous populations in Colombia to continue advancing in its very relevant tasks, and of course, the HEP, the Special Jurisdiction for Peace, that which advances in different cases with the opening of new cases and with the launching of, for example, a new case on sexual violence. Well, they've done very important progress, and also the public audiences or hearings, rather, which have been very powerful and compelling with acknowledgement of all those crimes committed, as well as all of the advances and progress that we've seen in the last few days with the issued conclusions for the case 003 in Catatumbo that have been taking great strides towards the imposition of sanctions that are also so important, and where the UN will also play a role as a request from the different parties. I want to recommend the following two things. Well, I want to highlight the important role that the UN has had with its most important organ from the from the United Nations Verification Mission in supporting the HEP in this path and supporting this system, this unique and innovative system, as Mr. Ambassador from Switzerland just mentioned, which most surely not only will provide lessons for the Colombian context, but surely for other contexts in the future. In Today in this conference, I think we will seize those two contexts for the Colombian context, but I'm sure that this system, we are sure actually, that it will continue providing important lessons to the world and the support of the mission specifically as a representation of that will to continue supporting Colombia and that process, also the role that the mission will play, that we are ready to continue playing that role, in this case, to verifying once the sanctions have been imposed to all those appearing for crimes committed. This is a complementary mechanism for the mechanism that has been installed or established for the compliance of the latter and will create the trust that also the appearing stakeholders are compliant and that victims feel repaired and that the country can continue advancing. So I did want to just seize this opportunity and thank, as well as acknowledging the importance of this conference and reiterate the support from the UN, reiterate the support from the Secretary General, whose visit to Colombia was an opportunity to reiterate the importance of the system and also of the special jurisdiction for peace. And I just want to communicate that we will be accompanying this process. And I also want to celebrate this conference, which most surely provide a lot of support that to this work that in a collective manner, the participants as well as the Colombian institutions and also all Colombia must continue doing with the support of international stakeholders to continue advancing in this path of peace, in this path of reconciliation. So thank you very much once again. It's a pleasure to be here. And I will be joining you, and the mission of the United Nations Verification Mission will be here. And thank you very much for your invitation. Thank you very much, Mr. Ruiz Macion. In the second international conference, Emerging Responses to Contemporary Atrocities, we have the support of the Commission of the for the Clarification of Truth, Coexistence, and Non-Repetition, and that's how we want to now hand the floor to Francisco de Ru, former president of this commission. So, Father Francisco, welcome.
I'm having trouble turning on my camera. Can you please help me turn on my camera? We are listening to you, so let's look at the bottom part of Zoom. Father, you will probably see the camera icon. I cannot start the video because the host stopped it. Perfect. We're going to ask. There we go. We can see you now, Father. Welcome. Thank you very much. Thank you, Clara Marcela. To all the people who are listening to us today, it's great to be together here this morning in the Americas and in the afternoon in Europe and in other parts of the world. Ambassador Eric Mayoraz, thank you very much for being with us and for your remarks and for the continuous support from Switzerland to these Colombian efforts. We want to thank you also for the extraordinary support from the international community. Thank you, Carlos Ruiz, for your support and for the efforts that you have exerted into the peace process in Colombia and for the huge meaning of the mission for our country and for our victims specifically. Of course, I also want to send special greetings to Eduardo Cifuentes, and I want to thank you, Eduardo, for your achievements that you have been able to attain in a such significant manner at HEP, and for the admirable achievements, and also to Ms. Sandoval as the Vice President. And Mr. Izquierdo, we feel great hope with your arrival to HEP, and we want to thank the commissioners and everybody at the commission. I also want to congratulate the magistrates at HEP for this decision. I also want to thank and greet Álvaro Gil Gomez, who's here with us from the appointment committee, because you actually made great work with these appointments. And to Pablo de Grace also, who's also going to be with us soon. I want to take advantage of this opportunity, since we have a large group of national and international participants listening to us, to stress the meaning of the system of justice, reparation, and non repetition because it places victims in the center, because through the special jurisdiction for peace, it ensured what victims were asking for with their entire soul. And we saw that in the country we needed a restorative justice that deeply changes the system of criminal justice because it tries to reconciliate a country and also to ensure that there's no impunity. And this is hugely thanks to the negotiators at Havana to ensure that the parties, especially the men from the FARC, to be part of a process of impunity and to allow it to prevail in the country. The Colombian state as well, especially the members of the state committed to the non-repetition of war crimes, but it has always been a justice referring to full restoration and transition. And then also to continuously over the years to focus on the hardest point of victimization, which had been led by Luz Marina and her team in these collective efforts that we have exerted in the search for people who had been considered disappeared. And this is where the Truth Commission, in this sense, I want to thank all my colleagues in the system, the United Nations, the international community, for the wonderful support. The Truth Commission, because it played a role of showing the truth to the community. We needed to show that this was a serious matter. We needed an institution in Colombia where the Colombian state would be committed to listening to the victims who were asking for truth. And first, to listen to the magnitude of their suffering. In that listening process that does not require any type of interpretation. That's where we have the pain of the mothers, of the children, of Afro descendant communities, of indigenous communities, of the LGBTI community, and the farmer community, to listen to them openly, also to listen to the military members who have been struck by war, and the entrepreneurs who have been struck by war, and also the middle income societies who had been struck by war. And in the midst of that, to start addressing what the victims were asking for. Why were they victimized? Who are the parties responsible? Who wanted to victimize them that way? They were looking for political interest and money. Because in Colombia, we have had more than 110,000 teenagers who had passed away during these struggles. And for every combatant, 2 additional people who were non-combatants also died. This amounted to almost 10 million people who survived from massacres, displacements, false positives. I want to highlight this because the Commission, at the same time that it had been exerting collective efforts to give an explanation of what happened with the truth and the affirmation of the truths and the affirmation of the patterns of the facts, at the same time, it was also mobilizing, with your help, an entire country so that the country would rise above all the complications behind peace and to understand that we didn't want any more victims, no more victims. And I think that this is what makes the system so strong, this system that we were able to achieve in Colombia. This was the mobilizing power in the country so that the truth would be positioned as a public right and the truth of victims, a system for non-impunity based on the truth and in the restoration of perpetrators and victims, and also the parties responsible. This had been reached in agreement with all parties, and therefore this has also been a main point to address the most painful aspect, the crime of disappearance due to forced disappearance. I also want to thank the committee integrated by the Commission to ensure that the recommendations are implemented, and we also feel satisfied in the midst of our political struggle, but also in the process of the elections. We have been able to ensure that President Petro adopts the recommendations by the Commission. And on that day, he mentioned this to the country and to the international community. He said that he was going to implement fully. This means with all conditions and all consequences, he was going to adopt the recommendations by the Truth Commission. And of course, we did not have any conversation with the government team that was preparing the government plan for President Petro, but we did something that came from the depth of victims without intending to work on a government plan. But we wanted to clarify what the victims wanted in structural terms. And we were able to establish these basic things that you all know of, which is the full compliance with the Havana Accord without leaving anything behind. And specifically, the issue with land, which is a main aspect in Colombia, and the solution of drug trafficking without war that did not lead us anywhere. The war against drug. But in the conviction that we have at the commission is that we need to combat drug trafficking in Colombia. Otherwise, it'll be very difficult and practically impossible to abolish all forms of violence. The security system is not about not creating an army for war, but an army for peace. The request to the international community is please help, but don't help us for war. We want to make Colombia a global benchmark of conciliation. And we want the security system to be at the service of people, of the population who are truly the most affected parties, and above all as well. We strongly insist in protecting the system. HEP, in our huge task that we continue to delve into, and of course, the victims unit, we also insist on preventing impunity in all forms. And therefore, we need to strengthen the system of the judges in the structural transformations based on the territories. We also need a cultural and educational transformation, which starts with a full openness without any restrictions to our indigenous communities, our Afro communities, and especially to those of the people from the LGBTI community who were affected unproportionately by war. And we also want to invite us all to build an ethic built on humanity. Once again, I want to thank you. I just wanted to mention these couple of things because it is this power of mobilization of a country that truly allows us to understand. I want to say this honestly. What the Colombian system, justice, reparation, and non-repetition offers to the world in this long process of the truth commissions around the world. Thank you very much, Father Francisco de Rue. We also want to welcome Magistrate Eduardo Cifuentes, President of the Special Jurisdiction for Peace. The floor is yours. Good morning, Mr. Eric Alain Mayoras, Ambassador of Switzerland in Colombia. I want to take advantage of this opportunity to thank you for your cooperation and your support that we have always received from your government. Special greetings to Mr. Carlos Ruiz Maciú, Special Representative of the Secretary General and Head of the Verification Unit of the United Nations in Colombia, who has also represented the awareness in Colombia by the United States and to continuously support the system for peace. Also, special greetings to Father Francisco de Rue, President of the Truth Commission. Your life has been a radical commitment to peace and to truth. Special greetings to Madam Luz Marina Monzon, director of the unit for the search of people who have been considered disappeared. Also, special greetings to the magistrates for peace and the chambers for justice, Mr. Executive Secretary of HEP, the officials of the jurisdiction, contractors, and other participants in this seminar. For me, it is a great pleasure to open this international event regarding the emerging responses to contemporary atrocities, where we will be discussing for 2 days on the different methods in which societies respond to the serious crimes committed within the framework of armed conflict or in an authoritarian government. The experts that have been invited will tell us about different experiences to face the past and also several institutional arrangements to ensure that these crimes are not committed again. We have several transitional arrangements. Some of them are based on the use of imprisonment as the main pillar of the system. Others on the determination of truth of what has happened in the past. And others, it's based on a combination of different mechanisms to be able to address all complaints submitted by the victims, for example, the right to justice and reparation. The Colombian government has changed over time, and this is a result of the political demands of every moment in time. In the first instance, in the past, this was faced through amnesties and pardon policies based on the fact that the atrocities would continue to be investigated during ordinary justice. We're really sorry, we're having audio interferences. And that the political crime was that what would truly identify armed stakeholders. Subsequently, in the peace and justice model, these atrocities were tackled with imprisonment, even though they were also part of ordinary justice. And finally, the current model as well, which is going to be a combination to retribution and restorative responses to be able to obtain a holistic approach to past of mass violations to human rights and humanitarian rights. In relation to sentence C 370 of 2006, which has addressed the matter of proportionality in the context of transitional justice. This topic emerges again with the sanctions as well that include a retributory and a restorative element. In the second aspect, there doesn't seem to be a problem to a point that the work and the activities undertaken by the defendants need to include a restorative element, but it actually should achieve a more modest purpose in the restoration of the ties in the community and the possibility for the victims and the defendants to be reintegrated in the political community as subjects with equal rights. But perhaps the biggest challenge for HEP is the achievement of compensation elements. And I would like to mention two possible methodologies. First, we can understand retribution as the response by the state given the commission of a crime and that follows the imposition that has been assigned. In this sense, all sanctions have to be proportional to the damage caused, following the logic of an eye for an eye. However, this perspective is based on punitivism, and it can lead to an immoderate implementation of criminal sanctions. What we need to ask ourselves is then, what is the proportional sanction in crime against humanity, genocide, or a war crime? On the other hand, as criminal law has acknowledged for several years, the retribution of the damage caused cannot serve as part of the sentence, but it's rather its limit. This means that no sanction can go beyond the damage caused on the victims. This means that there isn't no duty of imposing sanctions in an equal proportion to the damage caused, and therefore the states can impose sanctions that, retributively speaking or compensationally speaking, are less, as long as the purposes of justice are achieved in a different manner, such as with truth and with reparation. The sanctions, as such, that constitute one of the most significant contributions of the Colombian process, serve a main purpose of restoring the broken
Recording
ties
stopped.
in the community, which are the result of a process of investigations and the assignment of responsibility. This means
Recording in
that
progress.
they are related to the a serious crime can retribute because of the causes and they respond to the same. As a result of that response, we do have a transformational moment in which the parties responsible for an international crime, and therefore they acquire the obligation of identifying their behavior against their victims. As we will see in this event, the responses to the atrocities in the present are different and varied. But given the framework of international criminal law, all of them need to ensure that the state is going to fulfill a minimum justice level and that in any case, the truth of the facts will contribute to the victims. Events of this nature don't just allow us to learn about similar experiences, but also it allows us to think about what we do collectively and why we do it. The challenges that we're facing require us as an institution and demand from us the ability of thinking and creating and to give an order to the complexity through higher complexities. That was the advice of German sociologist Nicola Luhmann, to immerse ourselves fully to be able to understand. This is what Havian would recommend. So I invite us all in this event to think about this fully with the purpose of discussing in these 2 days about how to respond to the challenges that we are facing as a jurisdiction. I have requested and I have encouraged my colleagues to take action with audacity, with transitional audacity, so that we can respond to this. And the way that we respond to this would depend, the future of the legitimacy of our work will depend on that. Thank you.
Muchas gracias,
Thank
magistrada.
you very much, Magistrate Cifuentes, and from the comprehensive system of truth, coexistence, and non-repetition, we want to welcome Luz Marina Monzon, the director of the Unit for the Search of Disappeared Persons.
Doctora Luz María, bienvenida.
Luz Marina, welcome. Please take the floor. Good morning. Thank you very much. Good day to all. Mr. President Eduardo Cifuentes, I'd like to greet you, the HIP, and all participants in this event, as well as my colleague Francisco, or Pacho dearly, as I call him, and of course, Carlos Ruiz, Monsieur, to Mr. Ambassador, and all who are participating in this event. And I, as director of the Unit for the Search of Disappeared Persons, as part of the Comprehensive Systems for Peace, I'd like to share some reflections after almost 5 years of having started functioning the System for Truth, Coexistence, and Non-Repetition. I think that the title of this conference is quite suggestive and also quite challenging, not only because of what it implies to really be accountable for atrocities, and especially atrocities that don't belong to the past, but that in a way continue happening not only in our country, but also in the world. So what opportunities do we have to really be able to think of ourselves creatively for the creativity in terms of ensuring non-reputation? I think that's one of the main challenges, which I feel that transitional justice is facing all around the world, actually. But that is actually a huge opportunity that are enabled with the transitional justice system and how this has been thought and how it has been functioning in the country. We faced great challenges, great difficulties, the ones we faced in these almost last 5 years. Difficulties which I also feel have allowed us to strengthen in the development of a mandate with the utmost responsibility to really be able to serve something that is essential for the building of peace, which is exactly the contribution to victim satisfaction and rehabilitation. And now, just listening to Eduardo, I actually reflect on what people say about the complexity of the system itself, that the system is too complex to be understood. But I also feel that I think that the complexity is, or is rather, is laid in how we can creatively think about responses that have a very different format and a format that we've gotten used to. And I think that the jurisdiction, especially, is being accountable of these creative and consistent answers with a constitutional legal mandate that has been granted and also placing us in a very different position in the comprehension of justice that is closer to the needs of alleviation needs in relation to the impunity that causes a lot of suffering. And without a doubt, this is being done in the most responsible way. Now, before talking about the unit for the search of disappeared persons, I'd also like to talk about something that has always been quite interesting and that has motivated me in this transitional justice system, which is integrality and complementarity. I think that the system is thought and designed to act in a complementary or way or under the principle of complementarity. And that is very important because victims' rights are several, right? And the responses that they need are also quite varied. So to be able to have those responses in a synchronized manner so that the experience of integral or comprehensive satisfaction can be a reality, I think is an aspiration in the victim's experience ideal. However, in practice of the implementation, it is quite challenging. It is quite challenging because, well, because in general terms, institutions, let's please say the truth, do not act in a synchronized manner in general terms. I feel that the system has taken great efforts to act in synchronicity, but there are certain realities which are not very much taken into account at the moment when we think about the implementation of the mechanism, and it's that these have to be argued or sustained, meaning we need to implement this from, for example, having an office, a facility, to hiring humans, to defining methodologies, and also to start operating these methodologies. And then, and only then, one would be in ideal conditions to really be able to feel that one is implementing the mechanism. I think that all institutions here present of the comprehensive system, we had to do all this at the same time. And even more in the case of the Truth Commission. So I think that this synchronicity that is ideal in this model had a lot of challenges, important challenges. But as of these 5 years, I think that this is something that will certainly prove the potential and integrality and complementarity. How is this being seen by the unit, by the unit for the search of disappeared persons? As you may well know, the unit for the search of disappeared persons, it's a humanitarian and extrajudicial mechanism that has this very specific task of guiding and coordinating the search of disappeared persons within the context of the armed conflict. These are disappeared or forced disappearances that were caused through different circumstances that include forced disappearance, but also include other type of circumstances such as kidnapping, recruitment, and all this makes it so that there is a very, very specific and important need to articulate and to complement the work of the court or the tribunal from the HEP with the unit. And I think we've learned, and the case 001 certainly showed us certain opportunities and important challenges. And I say important challenges because what the accord says, and also the normative and the legal framework, is that a contribution of all those who appear before the HEP, they must contribute to the truth, not only in Truth Commission, but also in the unit for the search of disappeared persons. So case 01 basically made it so that all appearing parties must contribute or had to contribute to these two institutions. And we basically designed this work plan as of the understanding that this needed to be this contribution mechanism from the appearing parties, meaning the leadership from the FARC in the case of this specific case 001. This is a very challenging case because this is information that is certainly being complemented, and it is the element that at the end of the day can offer truth. But after this experience and the specific case of case 07, where we've had very important dialogues and exchanges and very smooth dialogue with magistrates, we've been able to understand a very important opportunity, which is the following one. It's about how, and that's exactly why we've signed a peace accord, especially with the executive secretariat of the HEP, how the TORS can be a medium that can contribute to the truth through a very specific methodological plan, which are regional plans. So instead of having a general promise from all appearing parties to the HEP that they would contribute to the truth, the, the main objective is that we have a very specific promise in the contribution in terms of this regional plans for the unit for the search of disappeared persons. And we've been exchanging about this with the special jurisdiction for peace so that this is also reflected in the sanctions, and that the search and the contribution for search, which is actually a reparation measure, can actually be included within these sanctions, such and so that this principle of complementarity and integrality can be a reality in the functioning of the comprehensive system. So I think we are certainly maturing, and I must say it as I think it has been mentioned before, we've been building this jointly. We've been building in the day-to-day tasks of the Truth Commission, of the Special Jurisdiction for Peace, and of the Unit for the Search of Disappeared Persons. And that is how we actually have created really a comprehensive system for justice that certainly creates hope. And we are fully committed, and we are at the forefront of these institutions. However, undoubtedly, this wouldn't have been possible without having the participation of victims and all civil society organizations, because these are the stakeholders that are permanently calling us to action, claiming responses, not only general responses of satisfactions of rights, but also of the functioning of each of these mechanisms. And I want to thank all these stakeholders because they are active political subjects in the construction of this system. And with the construction of this system, well, the peace building process that we must achieve. And I think that these notes from the Secretary General from some years ago about how transitional justice systems can contribute to the strengthening of the rule of law, and how he mentioned how the importance of the participation of civil society organizations within the implementation of these transitional justice systems. And I think that Colombia and the civil society and the victims have done it in an exemplary way and in a very responsible way and in a very permanent manner as well. So I want to just publicly acknowledge and thank all those organizations, the victims, and all those ethnical peoples who have also committed in allowing us to carry out previous consultations that are certainly pertinent so that the system can respond in an efficient manner to their expectations and to their needs in the peace building process. I would also like to quote, read this quote that I recently read. I was reading an interview made to Maurice Tidman. He is a person, well, he was the first person in charge of the forensic area for the International Committee of the Red Cross. And I just want to quote him due to the following, because the search for disappeared persons, I think, is one of the most important tasks, perhaps from my perspective. And of course, I may be a bit biased because I am not only the director of the unit, but also I am a human rights defender that is very committed with the search of disappeared persons. And I think it's one of the most important agreements from the negotiation table and also most challenging ones because searching for disappeared persons is a very, very challenging task. And when we talk about the search of disappeared persons, for those of you who don't or aren't familiar with the angst and permanent pain of all those families affected, perhaps you don't fully understand, and I will now use quote unquote why we need to seek for the dead and find them, and that's quite painful. Saying this is very painful in different realms, and not so long ago, someone mentioned in the Congress that there was a lot of expenditure within the unit because the results aren't reflecting the objective of the unit. And perhaps I think that the task is not sufficiently understood to really build peace, searching for disappeared persons. And that's why I want to bring this quote. Not only is it about the dead, it is also about those living, because we are all an integral part of the dead. And when we work for the dead, we also work for the living. The family members are a very close example, but this goes much beyond. It is about the essence of our humanity. Searching for disappeared persons is how we can recover the humanity that this very prolonged violent context has taken away from us, such as the one we have lived in our country. Thank you. Thank you very much, Luz Marina, and to all the parties of the comprehensive system of reparation and all the comprehensive system, also the magistrate of the Constitutional Court, of the Special Jurisdiction for Peace, Eduardo Francis, Mr. President Eduardo Cifuentes, Francisco de Roo, former president of the Truth Commission, and Luz Marina Monzon, director of the Unit for the Search of Disappeared Persons. Now I'd like to hand the floor to Danilo Rojas, the director of this international encounter, who will introduce our first guest. So please take the floor, Magistrate Danilo. Thank you very much, Clara, and good morning to all. Thank you very much for joining us and participating in this second international conference from the Special Jurisdiction for Peace to exchange about these very important topics on transitional justice, to find out what is the state of the art in the different measures, models, practices of transitional justice all around the world. It's a pleasure for me to introduce our next speaker, and he will provide the inaugural conference of this international conference. And he is Pablo de Grave. I think he is a person that certainly doesn't need an introduction. He is a Colombian fully dedicated since many years ago, I would say, I think all his life, to these topics in relation to transitional justice. I think Pablo is the most important international expert in this transitional justice topic without a doubt. His text, his publishing, his experience, his daily tasks, and his committed with truth reparation reflects this. Also, the way in he is always aware of what's happening around the world. I would only just like to remind those of you who do not know Pablo de Grave. Pablo de Grave was Director of Investigation for the International Center for Transitional Justice, the ICGJ, by its acronym in English, headquartered in New York. And that's where he led different research, investigation supports to transitional justice systems in different parts of the world, in Guatemala, Morocco, Peru, among other countries. Later, he was the first special rapporteur from the UN. I think, if I'm not wrong, that was for the year 2011, on the promotion of truth, justice, and reparation and non-repetition guarantees. This institution that at that time the UN created for this purpose. And from that space, Pablo presented different topics to the Council of Human Rights and to the General Assembly, also reports for visits to different countries such as Uruguay, Tunisia, the United Kingdom, Northern Ireland, Sri Lanka. And after this, as a researcher, as also professor and faculty of human rights from the University of New York, where he directs also the Transitional Justice Program, and he has contributed from the academia quite significant contributions in this field of knowledge. He's also been professor, guest, or invited professor, also from his alma mater, the Yale University, Cornell University, and of course NYU. Other European universities, Latin American ones as well. So I think certainly Pablo, or actually to just highlight the prestige of this speaker that is joining us. Perhaps you may well know that he is now currently part of the Investigation Commission for Ukraine, approved by the Human Rights Council of the UN to research this very aggravating situation that is currently happening. So aside from being very glad that he's joining us, I just want to publicly thank him for making time in his agenda to join us in this conference. I will actually confess the following. Pablo, when I talked about this conference with you, you mentioned, even though, regardless of the fact if I am in Ukraine or wherever I am, I want to be part of this conference. And I think that speaks of the commitment that Pablo has, especially with the case of Colombia. So once again, Pablo, thank you so much for joining us.
Thank you, Danilo, very much. Before we continue, I need to make sure that you're listening to me, right? Thank you, Danilo, for your generous welcoming remarks. Of course, I'm always afraid of your remarks because it makes sure that what comes next, it's going to be an exception. So thank you very much for the introduction. And with this, I think we have completed all formalities. The only thing that I wanted to do is to send special greetings to those of you who are sacrificing your time and you have taken charge of each of the parts of the comprehensive system in this process that Colombia has embarked itself on. I want to acknowledge Luz Marina, Eduardo, Father the Rue. All of you are Colombians, and the rest of us are truly indebted to you. I was kindly invited to give a global assessment of the status of transitional justice in the world. And I intend to do this in the half an hour that I was assigned. So I am going to be brief in each of the aspects. And I want to start out by saying that transitional justice has achieved important goals, including the following. I want to start with general comments. First of all, the field has been able to achieve its own consolidation. This cannot be taken for granted. You might remember, if you have followed the history in the field, you probably remember that the field started with intense disputes between those who defended a punitive approximation to the violations of human rights and those who pretended to adopt an approach that would include criminal justice elements, but that also included others. And that debate at the beginning took place in a dispute between truth and justice. Like all fields that defend a series of measures, the consolidation of these measures in a comprehensive policy shouldn't had been taken for granted. And this was a great achievement, in other words. But by 2020, but by 24, in the journal report by the Secretary on Transitional Justice and Rights, the Secretary could already talked about the four elements of transitional justice: justice, reparation, and reparation. In terms of a comprehensive policy or holistic policy, as if there wasn't any type of tension between the different measures, but taking consideration that they were complementary measures. I think that we have to congratulate these achievements. And secondly, I wanted to mention that transitional justice in a relatively short period of time was able to achieve its normalization. And by using this term, I mean that in a period of 20 to 30 years, it has been able to achieve a regulatory standard at the international level. There's no country in the world right now that is going through a series of transitions of which we do not expect that they consider or at least implement some of the elements that we call transitional justice nowadays. And those of we who work in transitional justice, we know that to achieve a regulatory change in a period of 20 to 30 years, it's a huge achievement. So now I am going to talk about more specific achievements, but that are similarly important. I think that the great achievement of transitional justice consisted and continues to consist in the separation of the different elements of the hopes for justice. This means that transitional justice always understood that a criminal approach to the crimes that concerned them was not enough to satisfy the justice demands from the victims, and that together with criminal justice, it was necessary to satisfy the truth and the need for reparation, and especially the imperative need to prevent the recurrence of those violations in the future. And based on this conceptual starting point or this separation, they were able to create a comprehensive policy, which is quite familiar for all of us. And fourthly, and as a consequence of this, I think that an important achievement of transitional justice in all countries that are included in the agenda. And I also want to emphasize that this happens even before implementation, but only when it is included in the public agenda. The effect of that would be the visibility of the victims. This means that victims acquire a space in the public domain that probably they had never had before. And I think that Colombia is the perfect example for this. I believe that the leading class in Colombia thought about armed conflict in Colombia for decades. as if it was a conflict that would predominantly threaten the economic structure of the country and also against the physical infrastructure of the country, but which was a conflict without any victims. And that radically changed. And it radically changed, I repeat, to a before the implementation of the transitional justice measures. It changed when transitional justice was incorporated in the public agenda. And this is important because of several reasons, including the fact that, of course, one of the fundamental purposes for transitional justice is related to the construction of a common political project. And when there are types of marginalization, full marginalization, as the case of the victims in Colombia, then it is difficult to affirm that we are in the presence of a common political project. This means that the visibility of the victims is one of the great achievements from my own perspective about transitional justice. And this effect has been magnified over time through the use of participation and consultation processes, which have been progressively incorporated in the transitional justice processes. I also believe that even though we still have long path ahead of us, in transitional justice, we've always seen certain progress in terms of its approximation to gender issues. The first truth commissions, for example, did not address this issue in an explicit manner. It is now completely impossible to think about a transitional justice instrument that does not consider a series of topics related to gender. And I think that this also shows certain manifestation of progress in a constitution of transitional justice, despite I insist on the fact that there is still a long road ahead of us. And as a final remark, I want to say that we've also made great progress in the documentation and the collection of evidence. These are processes in which transitional justice has also contributed to. I think that the construction of cases, the training in terms of collecting evidence in a way that it can be used in different judicial instances is a great contribution of transitional justice. In Ukraine, for example, as Danilo mentioned, I am working here. Training in relation to evidence collection, for example, has been noticeable. And there are already several manuals that are being used habitually by civil society movements as well, and also competent authorities in relation to evidence collection and documentation. And I think that this is also important, which also serves to the cause of justice, and not just seeing this from the perspective of criminal justice, but also this evidence and the collection of cases serve for truth, for reparation, and for the guarantees of non-repetition. I also believe that transitional justice has made great contributions in each of its elements, both at the regulatory level as well as at the practical level. For example, in terms of criminal justice, it was through the exercises of transitional justice of different countries around the world where they learn to mitigate the effects of amnesties. And I think that this is an important lesson. I believe that through transitional justice processes, we learn to articulate prioritization and criminal prosecution strategies that would allow the selection of certain types of cases for the effective use of investigation resources, which were scarce. I also believe, for example, that it was through transitional justice exercises that the world learned to diversify the judicial instances. In addition to the courts and the national courts, for example, we could also go back to a tradition that had started out with Nuremberg in relation to international courts and now including the International Criminal Court as well, but also hybrid courts and also the use of universal jurisdiction. So these are regulatory contributions in the sense that they have created a context and they have made the right of victims to justice a reality, as well as practical contributions because they have shown how this right or this law can acquire tangible reality for a large number of victims around the world. In terms of the truth, of course, transitional justice was the greatest contributor, and it also contributed to signing the right of victims to the truth. And again, not just from the regulatory and doctrine perspective, but also from the practical standpoint through the mechanism that is probably the one that is mostly identified with transitional justice, which means the truth commissions, but also through other instruments such as this diversity of truth commissions, including research commissions for specific countries, such as Ukraine. In terms of reparation, transitional justice also, for the first time, made the right of individual victims a reality, and this is the right to reparation. Of course, the world had known for centuries about interstate reparation after the different conflicts, but it was transitional justice in intrastate conflicts that actually shaped the right to reparation for individual victims. It was no longer about a state to another transferring reparations because of war reasons, but it was now the state providing reparation to individual victims due to violations against their rights. And transitional justice made this right a reality. It actually gave it content in practical terms through the creation of administrative reparation programs and administrative programs that also distributed a complex series of benefits. This means that they weren't just mechanisms to transfer compensations, but they would also distribute their beneficiaries a series of advantages or benefits that went beyond compensation. And finally, I believe that transitional justice has made a less acknowledged contribution, but equally important to the concept of the guarantees for non-repetition. Part of the problem here is that the term itself is not a usual term. I think that it would be better to talk about prevention, violations against human rights, in the strict sense, but transitional justice has also put this topic in the agenda. This, I believe that we also have a long path to go in this sense, but I believe that the future of transitional justice depends on how we go through this path. But the point is that behind transitional justice, we always had the promise or at least the offer of the never again. And that even though we haven't collected the lessons learned systematically and over time, and we still continue to think about this in terms of institutional reform and especially reform of the security entities or bodies, which is absolutely vital. But I believe that the prevention elements go beyond that. And if we have time at the end, we could probably address this again. These are the achievements of transitional justice. And from this perspective, I believe that the balance that or the analysis that I was asked to give is rather positive. But we cannot be naive either. I believe that transitional justice also faces great challenges. It faces three external challenges, and by this I mean challenges that don't necessarily arise from the traditional perspective and the way in which they conceive their work, but these are challenges that arise from the context in certain sense, in a global sense. And I want to mention three of them.
There's one which is quite known and is within the agenda that has to do with selectivity and the implementation of the international obligations. I think that the selectivity certainly challenges quite significantly the work of transitional justice. It's quite difficult for the international community to stimulate countries that are facing great challenges in terms of justice when some of those countries that are trying to provide incentives do not apply, or this does not apply. Sorry, they do not apply to their own challenges and their own cases the same expectations and the same regulations. The second general challenge has to do with the safetiness of many topics, meaning with the notion that there are threats that constitute existential challenges and therefore deserve exceptional responses. I think that this is a trend that is easily seen, for example, in the fight against terrorism, but also for many years, this has been evidenced in the fight against drugs. And to think that the challenge was so big that it deserved exceptional responses and that therefore it was not necessary to actually comply with the rights of victims nor with international obligations, customary ones of the different countries. And the third general challenges that transitional justice faces has to do with the increasing trend to limit the space of action specifically for civil society organizations. The amount of countries that have limited the action space for the civil society and establishing all kinds of restrictions from, for example, immense obstacles to registry, such as, or very expensive requirements in terms of reporting and registry, actually surpasses quite exceedingly the amount of countries in the world that have even now, for example, sanctioned or criminalized rather common rights such as the right to object or the right to protest. However, transitional justice also faces internal challenges, and I would like to now focus on two or three. Firstly, I believe that as transitional justice has evidenced in its initial years to be a very efficient tool, now this is not only being used in several contexts, but also we've seen two specific phenomena that I think we should be concerned about. Firstly, the expansion of mandates of each of the instruments of transitional justice. The truth commissions, for example, have been assigned functions that are quite much more extensive, regardless of the fact that commissions are basically still the same instrument that they have been for years, meaning ad hoc institutions, normally underfinanced, that face immense challenges to comply their task. And the more functions these are assigned, of course, the more challenges they will face to be able to prove or show results. This accompanied to by this to this phenomenon is what some sociologists and economic experts have named morphological phenomenon, meaning that the same institutional form works as good regardless of the context and the needs. So, for example, the replication of truth commissions, even in contexts where it's not obvious what could be the essential contribution of a truth commission, is certainly a manifestation of that isomorphic mimic phenomenon, or the youngsters would call this a cut and paste in English, meaning just copying a model from one context to the other without really taking into account contextual factors and without really taking into account what I think is essential, which is the concept of functional adequation. Meaning, we need to ask ourselves the purpose that we are driving forward towards to, is it one that can be achieved effectively through the tool that we are establishing, or are we simply just engaging in a mimic exercise, in a repetition exercise? And I believe that to this extent, I'm I want to highlight the following. Part of the success of transitional justice started specifically from adjusting in a very aware manner to the context where it was arised and to the needs that it intended to serve. And the change of the model of transitional justice from the context in which it was founded, meaning post authoritarian contexts with strong institutions, to now post conflict context, and normally, not always, but normally with weak institutions. I think that this is a factor that must concern us because this threats the effectivity of transitional justice. So, just to illustrate this point, think about the following. We have two different types of cases, absolutely different. The Chilean and Argentinian case. These are early examples of transitional justice, both cases with successful truth commissions, with programs, reparation programs, in general terms, quite successful. This is not a field for perfection, of course, but in general, these are programs, reparation programs that have been successful. Each of these countries have over 1,000 officials of the armed forces that have been prosecuted and sentenced, meaning criminal justice has been quite active in each of these countries. And of course, in both countries, there has been institutional reforms in terms of prevention that explain why in countries where the military intervened quite frequently in politics have now undergone deep crises since these transitions without the military stakeholders showing the least interest in politically intervening as they used to do. On the other hand, we have countries where transitional justice has been attempted, countries such as Mali, the Democratic Republic of Congo, the Central African Republic, where once again, in my opinion, in this isomorphic mimic phenomenon, institutions, family or familiar institutions of transitional justice have been established. And I will briefly talk about the Central African Republic as a representative case of this. In the Central African Republic, there was a specific court established for severe crimes. A truth commission was established. To this truth commission, at least under its mandate, this truth commission was appointed with the responsibility to establishing reparation programs. But all this is happening in a country where the central government has quite a weak control over the national territory. 14 different armed groups are disputing, in current days, the control over different regions of the country. In the Central African Republic, there are no courts, or permanent courts rather. There are two sessions of tribunals or courts per year in three different cities of the country. In all the country, there are around 80 accredited attorneys. And of course, under these conditions, where the central government does not really control the majority of the territory of the country, well, to guarantee security both of the operators of the transitional justice institutions, as well as those as the safety of those who want to contribute and appear before them, meaning witnesses, victims, etc. Well, their safety is basically impossible to ensure. So it is under these conditions that, well, we shouldn't be surprised that transitional justice has found much more challenges and much more difficulties to provide results. But it is the case that these are the contexts where most of the work of transitional justice is currently occurring in the world. Among these two extremes, we have the Colombian case. And here I'd like to just seize this opportunity to congratulate once again those who have operated the system and celebrate, for example, the resolution on the case of Catatumbo specifically. Colombia has achieved to use familiar instruments of transitional justice. However, it has done it in a very creative manner. The resolution that I just mentioned, for example, is a resolution that takes quite seriously the acknowledgement to victims, which exercises also an immense creativity in the design of sanctions, which also insists in the central participation of victims. And I also believe that around the different lessons learned that emerge from this exercise in Colombia, there is a lot that the whole world can learn, including in prevention terms, as I referred to before. I just want to conclude after congratulating the country, and especially those of you who were in charge of the system, with just a warning. Colombia also faces the risk of expansion and isomorphic mimic phenomenon in its future of transitional justice. The opening of a system that has been designed very specifically to actually achieve very different purposes in relation to organizations that have another type of structure, another type of nature, etc., also implies certain risks. And it also implies the tendency to think that that same institutional form can work equally well, regardless of the context and of the individuals who need to be prosecuted. I believe that the risk of opening up the system to any type of organization could lead to two challenges. One, to perhaps confuse or rather blur out the purpose of the system that has been designed, for example, to take into account organizations that are illegal, but that could perhaps be considered as political actors. It is, it would blur absolutely that scheme if this transitional justice system is open to any type of organization. But I would think that the second challenge, aside from this, is not only for the comprehensive system, but also for the ordinary justice system to which a message would be issued in terms of incapacity in relation to the fact that they can treat their natural individuals through a different system. So, celebrating these achievements that the system up until now, I think, has gained, I would also like to just close off with this warning in relation to the safety of the future of the comprehensive justice system in Colombia. And I want to reiterate once again, I think the world can learn a lot from it. So thank you very much once again for inviting me. And I apologize that this is not an on-site event because I would love to have an on-site exchange with all of you. Thank you all. Thank you very much, Pablo, for this marvelous participation in this inaugural conference. Now, I'd like to seize this moment and the fact that we have some minutes left to just ask the following question. I confess this wasn't in the agenda, but I believe, Pablo, that this is a unique opportunity. And well, I wanted to just highlight that while you've insisted in your talk on, and you've done it as well in your publications, and I think it has been quite evident in your intervention, this concern that has always existed, which is what I would call a kind of minimalism of transitional justice that you've always surveilled. To actually maximize results, one must be minimal in the remedies of transitional justice. And this has been a theoretical debate as well that you've maintained with other colleagues. I specifically remember the debate with Luis Arbur in relation to this specific topic that has perhaps a more expansion vocation. And I want to take this opportunity, Pablo, given that, well, here in Colombia, we're seeing that sanctions that will be imposed by the JEP, at the end of the day, I think must conclude with a type of juxtaposition of the rule of law And I will just quickly refer to this topic for those of you who perhaps are not so familiarized with what we are doing in the HEP and what we have done, which is that the penalties for maximum accountable parties, perhaps those are most interesting to the HEP, will certainly be works of restorative nature, and that immediately is juxtaposed with the rule of law. If that is like such, and it seems irremediable that the agenda of transitional justice then is expanded. So for the Colombian case, we would at least find ourselves with this, uh, let's say, practice of juxtaposition between the restorative and transformative orders that we will issue in the different sentences versus that minimalist pretension. And I just wanted to ask your opinion on this paradoxical situation that might arise. Thank you very much, Danilo. I think your question allows me to insist in a point in which I agree with you. I have always been quite a defender of modesty in transitional justice. Transitional justice, well, precisely because of its success at the beginning of its process and what I've annotated in my initial observations, it achieved a great normative change at a global level in a very short period of time. And for many years, it served, I think, or it acted out as a teenager, let's say, meaning assuming that it had a sort of magical recipe to solve any type of problems. And I do believe that maturity consists of partly in acknowledging that there are problems that cannot be solved with one sole tool, that there is not such a thing as a universal tool or as a a policy that can solve any type of problems of any nature. And I think this is important due to several reasons. One of the main reasons is that I believe that to create expectations in victims without really having certainty about how these expectations can be satisfied, thus constitutes a very specific way of cruelty, because these are people that have suffered significantly and therefore creating or seeding expectations without having a notion of certainty of satisfying the latter, well, constitutes a huge mistake. I believe that transitional justice must and should take the notion of adequate functioning very seriously. The systems of transitional justice are designed for certain types of objectives and not just for any type of objectives. Institutions of transitional justice accept certain type of tensions and pressures, but not just any tension and any pressure. Some may work better in certain contexts than others, as I've included in my observations.
In relation to your question now, I believe that there's no sanction regime that has sufficient magnitude to be able to compete with the services that a social rule of law should provide. I believe that as part of the maturity of the transitional justice field, what we have understood is that instead of trying to colonize the transformation agenda of a country that is in transition, what it should do is to open itself up to wider coordination with other types of initiatives. Eduardo mentioned Lumen in his introduction. I confess that I have more Habermasian trends than Luhmann, but Luhmann actually alluded to the idea that coordinated systems have the great advantage of preventing the replication of crisis, and therefore, I believe that the solution to these potential challenges that you mentioned consist mostly in the coordination than on the attempt of creating an hyper-institutional system that can take charge of all the different combinations between the sanctions as such and the habitual services of social rule of law. But if we look at it in terms of magnitude and we think about the total budgets, for example, that are going to be invested in the sanctions as such, I think that it's hard to believe that there's a real competition between both. What we should try to do is to achieve coordination and harmonization in a way that these sanctions, of course, can achieve synergies with what a social rule of law that doesn't have unlimited resources and that supports one another instead of being in dispute one with the other. But the fundamental point for me is not just about competition as such, but it's about the level and the nature of contact between perpetrators and victims, and that we need a design of appropriate sanctions. But the recent resolution, I feel respect for it, and also for the participation of victims who in some cases said, no, some of the bills that are being proposed imply too much of an intermission by the perpetrators in our family environment or context, for example, and that is not acceptable for us. I think that these are limits that we need to be careful about, but the system is capable of doing it as we showed in this resolution. Thank you very much, Pablo. Again, we could certainly continue to speak about this topic for a long time, but I believe that we were able to take the most advantage of you on this occasion. Once again, I want to thank you for your presence, for your time and your generosity of sharing your knowledge and your time with us and with the participants in the whole world who is connected on the session and learning about your experience. Thank you very much. You have been very kind. Thank you again. Thank you very much to our first conference speaker for his intervention. I want to tell all the participants who are connected now that in this year, 2022, and with a group of victims representatives and the Special Society for the Jurisdiction of Peace, we have had 3 hearings for the recognition of crimes, for war crimes and violence acts. And one of them took place in Ocaña, Colombia, with 10 members of the public forces and the civil force. And there were at least 120 murders conducted within work times known as false positive cases. We want to invite you to watch this video prepared by HEP that is titled, Us, the Crazy People, Were Speaking the Truth.
Amamos a nuestros padres, amamos a nuestros hijos, amamos a nuestros seres queridos y cuando se nos arrebatan las vidas de esos seres, hay un vacío enorme en nuestros corazones que es irreparable y el secuestro es un daño al amor.
Mi nombre es Angie Daniela Arandia Ospina, soy hija del geólogo Gerardo Alberto Arandia Valentín, secuestrado el 20 de julio del 2000 por la columna Teófilo Forero de las FARC, en Puerto Rico, Caquetá, en una vereda que se llama Manzanares, mientras se estaba trabajando haciendo unos mapas cartográficos de la zona. Yo tenía casi 7 años cuando esto sucedió. Desde ese entonces estoy esperando saber de mi papá, saber qué sucedió con él.
Jamás se le debió haber privado a Daniela ni a ningún otro hijo de la oportunidad de conocer a sus padres y a sus madres. Estos relatos llenos de dolor y a la vez de tanto amor son aquellos que nos impulsan a nosotros a seguir encaminados a la búsqueda. No alcanzo a imaginar la angustia y el malestar de no poder encontrar respuestas esclarecedoras y contundentes que permitan dar un cierre a tanto sufrimiento. Entiendo que la esperanza, la frustración y la incertidumbre deben ser una carga muy pesada sobre sus hombros y espero eventualmente poderles aliviar ese peso.
Un momento como el que sucedió hoy en la audiencia de reconocimiento, donde Milton de Jesús Doncel reconoció no solo el secuestro de mi papá, sino los años de búsqueda y lucha por saber de él y por encontrar la verdad de él. No fue algo acartonado, no fue algo plano, lo que yo escuché de Milton.
Otras personas en proceso de reconocimiento.
Creo que esta audiencia es muy crucial, es muy importante para que los miembros del antiguo secretariado tengan la oportunidad de demostrarle no solamente a los secuestrados, a las víctimas, mejor en este caso, sino también a la sociedad colombiana, que tienen un verdadero arrepentimiento frente a esos hechos y que se comprometan a reparar a las víctimas.
Y por eso creemos también en las expresiones de perdón y de dolor que tienen los comparecientes. Hay que reconocer ese esfuerzo que ellos están haciendo.
Alguien me preguntaba, ¿usted qué siente cuando escucha estos relatos? Sinceramente, yo decía, sinceramente, yo quisiera que la tierra me tragara. Porque uno, como lo dije al final de mi primera intervención, siento un dolor muy profundo de que a nombre de ideas revolucionarias haya pasado lo que pasó.
Siempre he pensado que el diálogo es la mejor forma de arreglar un conflicto. Los conflictos no se arreglan con odio. Los conflictos no se arreglan con guerra, se arreglan con perdón.
La audiencia como tal y este paso y todo lo que tiene que quedar como por la parte judicial era necesario, pero para mí lo que fue más importante fue el encuentro con Milton, tener el encuentro con los comparecientes, poder hablarnos, poder reconocernos de verdad, poder tener esa comunicación directa, llegar a hablar de perdón, llegar a hablar de reconciliación, llegar a hablar de reconocimiento, no se iba a dar de un momento a otro.
Nosotros esperamos que se haga justicia y que haya una reparación integral y unas garantías de no repetición de estos hechos execrables y violatorios, crímenes de guerra como ellos mismos lo han aceptado y como la JEP lo denomina, crímenes de guerra y de lesa humanidad. A ellos, por ellos es que estoy aquí, por más de 403.000 víctimas de la fuerza pública, pero más de 2.200 soldados secuestrados y desaparecidos. Yo espero que la FARC realmente se comprometa a no repetir estos hechos.
Yo creo que el compareciente o la persona que haya tenido la oportunidad de compartir con mi papá, que se siente a hablar conmigo, que me cuente cómo lo veía, cómo percibía a mi papá, si habló alguna vez con él, de qué hablaba mi papá, cómo eran sus días malos, cómo eran sus días buenos en medio de toda esta cuestión. Para mí eso sería una forma de restauración.
Cuando yo empecé este caso, una de las primeras personas que entrevisté fueron los antiguos integrantes de País Libre, que era la fundación esta que se ocupaba de estos temas, y uno de ellos me dijo, es que tienes que entender que el secuestro es un crimen contra el amor. Digo que pocas veces lo he entendido tanto como en esta sesión.
Han pasado hoy 22 años angustiosos, tormentosos, tristes, donde hoy recibimos un aliento, una fe, una esperanza.
Estamos a puertas de un principio, ¿sí? Estamos a puertas de lo que espero sea un gran cambio. Que aunque no haya sido tan visible, pero desde el 2016 se vienen dando muchos cambios. Se vienen dando cosas muy importantes para la sanación colectiva que merece este país. Después de tener estas lecciones aprendidas con el secretariado, que se pueda escuchar para que también podamos hacer este proceso con todos los mandos medios y como todas las personas como tal que están dentro del proceso. Eso es lo más importante. Es que es el amor, es en base al amor. No solo el amor, más bien el amor tan grande que hay por mi papá, que nos permitiera justamente tener esta cercanía con Milton, con los demás comparecientes. Es pensar que la reconciliación es posible, que sanar es posible.
El secuestro es un daño al amor.
Kidnapping is a damage against love. Responding to the first hearing of recognition also held in Bogota this year in 2022. We want to invite all those of you who participated with us in these public sessions so that you can join us tomorrow from 8 a.m. so that we can continue with our academic agenda. We will hear about the important perspectives from analysts and what is happening with transitional justice. And we will also be talking to academic peers and judges about this topic. We also want to remind the magistrates for the Special Jurisdiction for Peace and other special guests to now stay online so that we can continue with the internal meetings that we have organized later. To all those of you who joined us this morning in this public session, we want to thank you and we want to invite you to join us back here in our second international conference. Thank you very much, and we will see you tomorrow. And those of you that are participating in the internal session, we will see you in 2 minutes. Thank you.